Good afternoon, Grade 12s. We're going to be looking at the Basic Conditions of Employment Act. It's often just abbreviated to BCEA. So we want to know what is the purpose of this act. And it provides very clear terms and conditions of employment for employers and employees. It sets minimum requirements or standards for the employment contract that is entered into. It regulates the right to fair labour practices as set out in the Constitution, and it adheres to the rules and regulations as set out by the International Labour Organization. If we look at the effectiveness of the BCEA, remember that's looking at the advantages and the disadvantages. So let's start off with the advantages. It offers a framework of acceptable employment practices. For example, it talks about how many hours of work one is entitled to work on a day. It talks about how much overtime you need to be paid, how much sick leave you are due. It promotes fair treatment of employees so that there isn't any vulnerable abuse that is happening, and it encourages constant consultation between employers and employees. It really does outline the minimum requirements that form the basis for every single employment contract, and this then helps businesses know what they can put into the contract. The work hours are specified, as I mentioned earlier. The negatives, however, are that drafting this formal legal employment contract may be time-consuming and also very costly. Businesses may not regard employment contracts negatively and may not therefore implement it, which then results in not being compliant. No employer may force an employee to work for more than 45 hours in 1 week. This may also result in a reduction in productivity. Hiring cheap labor is no longer possible, so businesses cannot exploit vulnerable workers. The BCEA forces businesses to comply with many legal requirements, which may then increase the labor costs. Let's move on to the next slide. So what are the discriminatory actions according to the BCEA? It forbids workers to discuss their wages and their salaries with co-workers. Please remember, boys and girls, when you do work for a company one day and you are given your salary slip, please do not share this information with any of your colleagues because it often brings about jealousy and conflict within the workplace. Your salary and what you earn is confidential, and it is professional for you not to discuss it with anyone else. It prevents workers from having access to employment contracts. So if you just say, I'm not going to give you an employment contract, that is a discriminatory action. That is something that is not complying with the BCEA. If you as a company refuse to accept a medical certificate from one of your workers who have been sick, that is seen as a discriminatory action. It is not allowed. So what are the penalties for non-compliance? Labour inspectors may serve a compliance order by writing to the Department of Labour. The Director General may agree, change or cancel the compliance order. Labour inspectors may investigate any complaints or questions and remove records as evidence while they are doing their research and investigation. Businesses may be taken to Labour Court for a ruling, and businesses that are found guilty of non-compliance will face heavy fines and other penalties. They can be ordered to pay compensation and damages to their employees. So what are the provisions of the BCEA? This is unique to the BCEA. None of the other acts have these provisions. So you must know these phrases very well, and you must know what each of these provisions is about. So the first one we're going to look at is hours of work. You may not work for more than 45 hours in 1 week. So in other words, 9 hours for 5 days. Workers may work 9 hours a day if they work 5 days or less per week, 8 hours a day if they work for more than 5 days a week. Night work performed after 6 in the evening and before 6 the next day by agreement must be compensated by allowances or reduction of working hours. Ordinary work hours may be extended by agreement by a minimum of 15 minutes per day and a maximum of 60 minutes per week to complete duties when serving the public. Ordinary work hours may be reduced to a maximum of 40 hours per week, which means 8 hours a day. But the general rule for hours of work is 9 hours a day, 5 days a week. Let's move on to the next one. Overtime. Workers must agree to work overtime. You cannot be forced to work overtime. You cannot work for more than 3 hours overtime per day and more than 10 hours per week. So if you work on a Monday, 3 hours overtime, Tuesday, 3 hours overtime, and you get to Thursday, you can only work 3 hours overtime there, and then by Friday, you only have 1 hour of overtime left. So that was Monday, Tuesday, Thursday, 3 hours overtime each on those nights. And then on Friday evening, you would not be able to do more than 1 hour because it's a maximum of 10 hours per week. Now you are paid 1.5 times your normal hourly rate when you work overtime. So using a simple example, if you paid 10 Rand an hour, then your overtime would be 15 Rand per hour. Let's move on. What about sick leave? There are a lot of different kinds of leave, and we're going to be discussing each one of them. With sick leave, you're given 6 weeks of paid leave in a period of 3 years, or you could say 36 months. So in other words, you get 1 day paid sick leave for every 26 days that you have worked. It doesn't mean that come 26 days you haven't been sick, you can now take a day of sick leave. You generally have to be sick to use that. But let's say in the first year, you get very sick and you need more than the basic 10 days in a year. You can go into the second year's sick leave and use that. It works in a 3-year cycle. And in that 3-year cycle, you have 30 days of paid sick leave. If you use all of that up and you're still very sickly, then it becomes unpaid leave. Now remember, a medical certificate may be required before paying you your sick leave if you've been absent for more than 2 consecutive days or you're absent quite frequently. Who can guess what the next one is? Yep, you're right, maternity leave. Right, so maternity leave is when a pregnant employee is entitled to 4 consecutive months' leave. A pregnant employee may not be allowed to perform work that is hazardous to her unborn child. The starting date is usually any time from 4 weeks before the expected date of birth or on advice from the doctor. Now, I'll tell you a little story. When I had my second child, I was very stubborn and I didn't want to take 4 weeks off before my child was born. So I said to my headmaster, please, I want to work right up until the Wednesday, and my child was the due date was the Friday. And he said, there is no way he's letting me do that unless I get a letter from my doctor to say that I'm healthy and I'm not at risk, which I did. And what happened is I worked up until that Wednesday, and on that Wednesday, at about 12 o'clock in the afternoon, I realized, oh my goodness, I think it's time for my baby to come. And I drove myself to the hospital, and at 3 o'clock that afternoon, my second son was born. So I worked right up until the day that my son was born, and then I had 4 months of maternity leave with my wonderful boy. So that's maternity leave. Right, the next one, family responsibility leave. You're entitled to 3 days paid leave per year on request in the event of the death of a spouse, so your husband or your wife, or a life partner, or a parent, or an adoptive parent, or your child or your adopted child. So family responsibility leave is also sometimes referred to as compassionate leave. So when you take leave to go and attend funerals. An employer may require reasonable proof before actually granting you leave, because remember, you're being paid while you are going on leave. Male employees are entitled to something called paternity leave, all right? And this is between 3 and 5 days when the little baby is born. The law is trying to change that to go from 5 to 10 days of paternity leave. But if you are asked in an exam, a husband takes time off because his child has just been born, what kind of leave is this? Please, you must say it is family responsibility leave, even though we refer to it as paternity leave. Right, let's move on. The next one is something we know as annual leave. So you know, as a scholar, you get holiday time. At the end of each term, you get a holiday time. So employees also have holiday leave, but we call it annual leave. So annual leave means that you have 21 consecutive days annual leave per year, which you're still paid for even though you're not at work. So basically it works out to 1 day for every 17 days worked, right? But you have to ask for this leave. You have to put in a request to take this leave. Now, when it says 21 consecutive days, if you go Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, those are consecutive days. But remember, for most employees, you are only going to work Monday through to Friday. So in fact, the 21 consecutive days leave really only boils down to 15 days leave of working days a year. So my suggestion is when you get your employment contract, which is going to be governed by the Bcea, you need to ask for more leave, all right? Because everyone likes to go on holiday and not have to work, right? So you can negotiate to have more than the 21 consecutive days. Please don't forget that, guys. It's very important. Right, the next picture you can see there's two people sitting there having a coffee break, taking time out. So this now is referred to as meal breaks and rest periods. And the BCEA says workers must have a meal break of 60 minutes, of 1 hour, after every 5 continuous hours of work. So if you arrive at work at 8 and you work from 8 to 9 to 10 to 11 to 12 to 1, at 1 o'clock, you need to be given 1 hour's break. What a lot of businesses do is they say, okay, work from 8 to 10, then have a 15-minute break, work from 10 till 12:30, then have a half an hour break, then work until 3 o'clock, and you have your next 15 minutes. So they break that 1 hour up throughout the day. But if you don't break it up, after 5 hours of continuous work, you must be given a 1 hour rest period. Termination. So what does this mean? Okay, basically a contract of employment may only be terminated following 1 week's notice if the worker has been employed for 6 months or less. So if I start at a new school and I really don't enjoy it and I want to leave, I can give 1 week's notice if I've been there for less than 6 months. But a minimum of 4 weeks' notice must be given if the worker has been employed for longer than 1 year. The employee must be given notice in writing. Okay, so you must write out a letter to your employer saying, I hereby am giving notice of my termination date. An employee who is retrenched or dismissed for restructuring reasons is entitled to 1 week's severance pay for every year of service. So if I've worked for a company for 20 years and I'm retrenched, they have to pay me that month's salary plus 1 week for every year I worked. So they would pay me an extra 20 weeks worth of salary. All right, so that is the minimum that they must pay me. If we look at the last picture there, any ideas what that refers to? There you go, it's public holidays. So workers must be paid for any public holidays that fall on a working day. All right, so if you work on a public holiday, by agreement, you are then paid double the rate. So that example of I use 10 Rand an hour, you would now be paying 20 Rand an hour. Right, gentlemen and ladies, how do you comply with the Basic Conditions of Employment Act? What must you do? So number one, you actually must follow every single one of those provisions, okay? So I've just put a few examples up there. You must have 60 minutes break after 5 hours of work. You have to work 45 hours a week. If you do overtime, it's a maximum of 10 hours of work. Workers can take up to 6 weeks paid sick leave during a 36-month cycle. So any of the provisions, if you mention those, that is how you comply with the BCEA. There's one issue I haven't spoken about yet, and that is the issue of child and forced labor. It is illegal to employ a child younger than 15 years of age. Okay? So in other words, we know that you can start working when you're 16 years old. It is also illegal to force someone to work. Businesses may employ children over the age of 15 years if the employment is not harmful to their health, their well-being, their moral and social development, and minors under 18 years of age may not do dangerous work that is meant for adults. So in other words, you can't be employed at the age of 16 to go and drive a truck because number one, it's illegal. You have to first have your driver's license. I hope that has helped. And please remember, when you get your first employment contract, you don't need to sign it straight away. You can negotiate for better deals. Have a good day.